Hi, my name is Elizabeth Olvera. I'm a legal document assistant in California, and I help people fill out the paperwork to file for divorce, legal separations, child custody, visitation, and support. I'm not an attorney. I do not give legal advice. Today, we're going to be talking about the uncontested divorce process. If both parties agree with the terms of their divorce, the parties don't usually need to go to a court hearing. In fact, most people don't even have to go to the court at all because when people hire me, I handle the process from beginning to end. Here are the steps to file for an uncontested divorce in California. The first step is the initial filings. You file a petition in the county where you reside, regardless of where you got married. California is a no-fault state, and so you don't have to give the reason as to why you're requesting a divorce. You simply have to state that you want one. The first document that you file with the court in order to get the divorce started is known as the petition. The petition will ask questions regarding your date of marriage, your date of separation, what your agreement is regarding spousal support, if you have any children, and what agreements you have made regarding child support, custody, visitation, and property division, among other things. Once the petitioner signs the petition, you can present the filings to the court for filing and pay the court's filing fee of $435 once we get the filed copies back from the court. Then we prepare the service copy to have the documents legally served on the respondent. The documents need to be served by someone other than you, the petitioner. There are a few options to serve your spouse. The first step is they can be mailed to the respondent through first-class mail. If the documents are served by mail, the respondent will have to sign an acknowledgement of receipt form, indicating that they received the divorce paperwork. Another option is to have a third party serve the documents, such as a process server vendor or a family friend. The server has to be over the age of 18 and cannot be the petitioner. The server will sign a document indicating that they personally delivered the documents to the respondent. Regardless of the method you choose, the date of service is very important because it starts 2 clocks. The first clock is a 30-day review period where the respondent will have 30 days to review the petition and determine if there is anything on that petition that they're not in agreement with. And if so, they may choose to file a response with the court indicating that they're not in agreement with the terms of the divorce. For divorces, the second clock that starts is a 6-month mandatory waiting period in California. No sooner than 6 months can the court order the parties officially divorced. Both those clocks run concurrently at the same time. The third step of the divorce process is preparing the financial disclosures. The court would like the petitioner to fill out financial forms to disclose all assets and debts, income and expense numbers as well. Along with these disclosure forms, the petitioner will need to provide 2 years income tax returns and 2 months worth of pay stubs to the respondent. These documents are not always filed with the court, but the disclosure does need to be made. Once we fill out and mail these disclosures, we file a document with the court indicating that the petitioner has complied with the disclosure requirements. The next step is we submit additional proposed judgment paperwork to the court that indicates that we have filed the petition, we have served the respondent, we have served the financial disclosures, 30 days have passed since the date of service, and that the respondent has not contested the case. That is, that the spouse has not filed a response with the court indicating that the respondent is not in agreement with the terms listed on the petition. Once the proposed judgment paperwork is signed by the petitioner, it's submitted to the court for processing. The court finalizes their review and the judge signs off on the paperwork if everything is done correctly. The final judgment is mailed to the parties directly. And that's the general process from beginning to end. Please reach out to me if you think I can assist you with the process or if you want to schedule a consultation to discuss the process and the timeline further. I'm not an attorney and this is not legal advice.